Hi everybody, this is Uma from Success Law Classes. Today we are continuing with the daily practical test series for AIB examination. The question number 6, which of the following writ can be issued against usurpation of public office? So the option A is writ of mandamus, option B is writ of certiorari, option C is writ of quo warranto, and option D is writ of prohibition. So the correct answer for this question is answer C. Quo warranto means by what warrant? Through this writ, the court calls upon a person holding a public office to show under what authority he holds that office. If it is found that the person is not entitled to hold that office, he may be ousted from it. Its objective is to prevent a person from holding an office he is not entitled to it. Therefore, preventing usurpation of any public office, it cannot be issued with respect to a private office. Then coming to the seventh question, Ridge versus Baldwin's case deals with here option A is corporation, option B is natural justice, option C is state liability, option D is delegated legislation. So the correct option here is answer is B. The natural justice means in simple terms is the principle laid down by the court of law for fair justice among the appellant and the respondent, exempting quasi-judicial. So this Ridge versus Baldwin's case is one such case of England that widened the scope of natural justice. This case is a landmark case of England since it introduced the new rule, that is principles of natural justice. Then coming to the eighth question, meaning of audi alteram partem. So option A is a person cannot be condemned without being heard. Option B is adjudicating authority must give a speaking order. Option C is no man can be judged in his own case. Option D is no one fear the courts. So the correct option is option A. This maxim means hear the other side, or no man should be unheard. Both the parties have an opportunity of being heard. Justice will be given to both parties. Audi alteram partem is from a Latin phrase audiator et altra pares. It means its meaning is also the same as here the other side. This is a very strong rule which means no one will be judged without fair hearing. The motive of this maxim is to provide an opportunity to other party to respond to the evidence against him. Then coming to question number 9, rules made by Bar Council of India in exercise of its ruling making power under which act it is. Option A is Advocates Act 1951, Advocates Act 1954, Advocates Act 1961, Advocates Act 1964. So the correct option here is option C, that is Advocates Act 1961. Explanation here is the Bar Council of India can make rules under section 15 of the Advocates Act 1961. These rules can cover various aspects such as election of Bar Council members, the chairman and the vice chairman, disputes resolution, filling of filling of vacancies, powers and duties of the chairman and vice chairmen, organization of legal aid, meetings and conduct of the business of committees, and management and investment of funds of the Bar Council. Then coming to question 10, which one of the following is not a ground of divorce in Hindu Marriage Act? Option A is mental disorder, option B is venereal disease in communicable form, option C is incurable unsound mind. Option D is living separately for less than 3 months. So the correct option here is answer D. Living separately for less than 3 months is not ground of divorce in Hindu Marriage Act. Thank you all of you. Please subscribe my channel and click on bell icon.